So in this video, I have a very important update in a major case against a statewide ban on the purchase and possession of magazines, and also a permit process that's in place. Now, before we jump into this video, I want to thank the sponsor of this video, which is Attorneys on Retainer. When it comes to self-defense protection, don't just settle for any company. AOR is backed by an actual law firm with real attorneys on staff that are focused on helping you. With AOR, you get direct access to an attorney 24/7 who can immediately help you with legal advice if you ever have an incident. So if you're interested in protecting yourself with the best company on the market, check out AOR using the link down below. And if you use the code ARMEDSCHOLAR, you can get $50 off your individual sign-up plan or $25 off of a family plan. As I mentioned in the intro, in this video, we're going to be discussing a challenge against a state magazine ban and also a permit to purchase process that they put in place. Oregon Measure 114, which put in place a statewide permit to purchase and the magazine ban, was ruled unconstitutional and struck down in its entirety by a state court judge. The state court judge, Judge Robert Roscio, in this case issued a permanent injunction against all of Measure 114. The state of Oregon, in response, attempted to remove that permanent injunction through the appeals process. Well, the Oregon Court of Appeals just issued a unanimous order upholding the magazine ban in Oregon and also that permit process. The decision by the Court of Appeals strikes down that permanent injunction issued by the lower court judge, but this case is far from over. Now, this case we're going to be talking about is called Arnold versus Kotek. We've covered it in the past, and again, this deals with Oregon Measure 114. Measure 114 first requires that anyone purchasing a firearm must obtain a permit to purchase. The second significant thing that it does is it creates a ban on the sale, purchase, transfer, and possession of any magazine that holds more than 10 rounds after the effective date of the measure. Now, in response to this measure, the Arnold versus Kotek case was filed in a state of Oregon court. Judge Robert Roscio ruled in this case that Oregon Measure 114 was invalid under the state's constitution and that it must have been struck down in its entirety with a permanent injunction. But of course, the story did not end there. Oregon then appealed that case and that decision up to the State Court of Appeals. They then asked for the Oregon Court of Appeals to reverse the permanent injunction issued by Judge Roscio and find that Measure 114 is constitutional under the Oregon State Constitution. Now, it's important to note that since this is a state challenge under the Oregon State Constitution, there is a different standard for the state court here to determine the constitutionality of the state law and to review essentially Measure 114. It is not the same Bruin standard. It's not text, history, and tradition. Oregon has their own precedent, and since this is a state challenge under the Oregon State Constitution, it's a little bit different. Under this standard, Oregon applies the two-phase test. Under Phase 1, there is a determination of whether or not Article 1, Section 27 of the state constitution actually applies. Under the first phase, Oregon argues that Article 1, Section 27 does not apply since they believe that these magazines are not arms and they're not protected by the state constitution. The plaintiffs argue that that is incorrect, that these are arms, and the Supreme Court itself has stated that all modern instruments that facilitate armed self-defense are arms and therefore protected. Now, the second phase of the test looks at the public's interest, and then it balances that against the harm against the constitutional right. So what is the public's interest in restricting, possession of magazines? What is the public's interest in restricting, access to firearms by creating a permit to purchase? And what potential harm would that cause on the constitutional right? The state of Oregon, in their Measure 114, argues that the measure is in the public's best interest to actually stop crime. However, the trial court judge found that through expert testimony and all the data that was submitted in the trial, that the public harm was pretty much overblown and that the measure does not meet the claimed interest. Like I mentioned, this case was appealed to the Court of Appeals, reviewed, and has now been decided. The judges that decided this case are Josephine Mooney, Darlene Ortega, and then Christina Hellman. My prediction after listening to the oral arguments was that the Court of Appeals here wanted to reverse what Judge Roscio said. I also stated that I believe that they were going to take kind of the easy way out and use the whole facial challenge aspect of this to find that the law is constitutional in some applications and therefore should not have been thrown out or struck down by the lower court judge. Well, that's exactly what they just ruled in this unanimous Court of Appeals decision. They held that all of ballot measure 114 is facially valid under Article 1, Section 27 of the Oregon State Constitution because the law is capable of constitutional application. Therefore, they reversed the permanent injunction issued by Judge Roscio. Now, in the opinion, the Court of Appeals stated that from the foregoing, the question we must address in this case is whether the enacting body here, the people of Oregon, enacted a reasonable regulation governing the possession and use of constitutionally protected arms in order to promote public safety without unduly frustrating the right to armed self-defense as guaranteed by Article 1, Section 27. In making that determination, we are addressing legal questions of the enacting body's purpose and the reasonableness of the regulation to achieve that purpose, i.e., whether the regulation is directed at and drafted to achieve the public safety purpose. They state that if, as a legal matter, the measure is a reasonable regulation to promote public safety, there is one remaining legal question. Is the right to armed self-defense unduly frustrated? That question, in turn, is not answered by the use of a balancing test. Any constitutional limitation on a reasonable regulation to promote public safety must be found within the language of our history of the Constitution itself. The Court of Appeals then goes on to say that they do not need to do whole fact findings or rely on expert testimony that was debated and developed in front of Judge Ratio at the lower court level. In fact, they actually state that the development was essentially worthless and kind of a waste of time at the lower court level, that they're not going to really look at that. All they believe that matters is whether there is a claimed public safety threat and if the public safety benefit created by the regulation, solves that safety threat. When it comes to the permit to purchase analysis, they state that the permit to purchase program and the point of transfer background check reflect a contemporary legislation response to identifiable threats to public safety and a legislative determination that the risk of death or serious injury to members of the public is increased by the threat posed by untrained and dangerous persons obtaining firearms. Therefore, they upheld the permit process as constitutional. They believed that there was a public threat, that there was a risk of harm to people, maybe by just anyone being able to purchase firearms without a permit or without training. And they claim that that threat is solved with the permit process, with the training, with the background check, and all the things that they put in place. Now, on review of the magazine restrictions, they state that we also observe that the magazine restriction is a contemporary legislative response to identified public safety concerns stemming from the advancements in technology and the availability of those advancements to the public that have created observable threats to public safety. By the findings contemplated by the people of Oregon when they enacted Measure 114, the use of these magazines presents a clear public safety threat to the welfare of the public because of the great increase in capacity to cause harm when a person may fire more than 10 times without having to reload. The ban on these magazines is a reasonable regulation directed at the specific observable public safety concern that the people of Oregon sought to address. And based on that, this Court of Appeals here upheld the magazine ban. So unfortunately, the Court of Appeals has upheld the magazine ban and the permit process in Measure 114. Now, this really isn't surprising. It seemed pretty clear when you listen to the oral arguments that that was the way that this Court of Appeals was leaning. And, I'm not surprised at all that it was unanimous 3-0 in favor of upholding Measure 114. However, I will state that this case is far from over. There is now the option to elevate this to the Oregon Supreme Court. Now, also interestingly, twice the state of Oregon tried to get the Oregon State Supreme Court to step in at an early period in this case on their behalf and block what Judge Ratio said in some prior orders with TROs and some of the other things that he did. However, the Oregon State Supreme Court denied those state requests. Now the Oregon State Supreme Court will have the option to take review of this case on the final merits and to determine whether or not the Oregon magazine ban and the permit process is in fact constitutional. And if they decide to not review this, well, then this can be elevated to the U.S. Supreme Court. So there's a lot of options still on the table going forward. I also suspect that the plaintiffs here, GOA, along with Arnold, they're going to seek some sort of maintenance of the permanent injunction that was granted by Judge Ratio to maintain the status quo while the appeal is still taking place. So I suspect that that will also be filed soon once review from the Supreme Court is also sought. So it's an unfortunate decision, but not all hopes are lost right now. Gun owners in Oregon, you still have a lot of options, and we're going to have to see how this develops. But unfortunately, bad decision. We saw it coming, but now this is going to be elevated to the next level. So as we get more information, as things develop, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by ARMED Scholars, and this nation will be maintained by ARMED Scholars.